Hello class, hope you're all doing well out there and staying safe. Today we are going to start a new topic of substantive law. We're going to talk about criminal law. And in talking about criminal law, there's probably going to be a series of lectures, 3 or 4. We're going to start off with an overview of crime in the United States. Then we're going to talk about the processing of a criminal case. Then we're going to talk about substantive criminal law, crimes against property and the person. So against person would be things like murder, assaults, batteries, that type of thing. And then the last thing we'll talk about are constitutional protections in criminal procedure. So this is where we'll talk about things like self-incrimination, search and seizure, and cruel and unusual punishment. But what we want to do is just start with an overview of crime in the United States. Criminal law is one of the most important substantive areas of law. And one of the reasons why it's most important is because of the extent of criminal issues we have in the United States and their impact on families. So let's talk a little bit about what crime looks like in the United States. Well, one of the things that we know is the United States has the highest crime rate of any Western industrialized nation in the world. Every year, 24 million Americans report being victims of a crime. Now, when you say 24 million, that's a large number, but when we're talking about a crime, we're talking about a crime of any type. The other interesting thing about that figure, though, is that it's been estimated that only 40% of victims report the crime. So there are a lot of people who are a victim of crime who never bother reporting it. So I can remember as a young teenager walking down Broadway in New York City and going to a movie. And when I got to the movie, I went to my back pocket to look for my wallet, and guess what? My wallet was gone. Now that's a crime. Someone stole it. But I didn't bother reporting it because I knew that would not be a very high priority for New York City police officers who were dealing with much more significant things. In the United States, we also know that there's one violent crime every 18 seconds. One murder every 24 minutes. And when you look at murders in the United States, just to give you some baseline, in 2000, the year 2000, there were roughly 16,000 murders. And we have the highest rate per capita of any, again, industrialized society, Western industrialized society in the United States. So in the United States, we have 6.3.6 murders per 100,000. Now, how does that compare to with other countries? So we have 6.36. The Netherlands has 1.66. Sweden 1.94. France 1.65. Italy 1.56. Britain 1.45. Germany 1.58. You get the idea. So our crime rate is at least triple. Our murder rate is at least triple any of these other countries. And this number has varied. So if you look at homicides over the last, say, 30 years, the low water mark has been about 15,000, and the high water mark has been about 25,000 homicides in one given year. So there is some significant fluctuation. And we find that, believe it or not, some of the fluctuation is accounted for by unemployment rates. The higher the unemployment, we see murders tend to go up. The other thing that becomes pretty interesting is that only 20% of crimes reported to police actually result in an arrest. So 20% of the reported crimes actually result in an arrest. And generally the way that works is, which is kind of consistent with what I said before, the more serious the crime, the more likely we will have an arrest. So, for example, again, using the example we just provided of murders, we find that more arrests are made in regard to murders than any other type of violent crime. Now, every year, police arrest over 14 million people for non-traffic offenses. That's a lot of people. Of those who are arrested for felonies, what we find is that the criminal justice system disposes of these cases in the following manner. And I think Baum provides a good diagram for you on page 160. So you might want to take a look at your book. But what it shows is, for every 100 felonies that are committed, 69 are carried forward, 23 are dismissed, and 8 are diverted or deferred. So what we're seeing here is that for the felonies for which people are arrested, 31% are dismissed or diverted. Only 69% go forward. Now, of the 69% that go forward, 55 are decided through guilty felony pleas. So in other words, a person pleads guilty to the offense. Then what we see is another 10%, or 10, excuse me, have guilty pleas to misdemeanors of the 69. So 65 of the 69 cases are resolved prior to trial through a guilty plea. That's 94% of all the felonies. So in other words, only 6% of these felonies are actually decided by a judge or jury. So what we're saying here is that our traditional perspective on how our criminal justice system works, that felons are arrested and then go to trial, is not the way most cases are disposed of. Most cases are disposed of through guilty pleas, and therefore the importance of plea bargaining. And we're going to talk about plea bargaining a little more later on when we talk about the process of dealing with the case. So when you look at how this varies by the different felony, again, look at Baum, page 185. And they break it down by sentences imposed by state courts for different felony offenses, the percentage that are sentenced to prison or jail, and what the mean maximum sentence tends to be. So if you look at that table, of those people who were charged with a murder, 95% of them are sentenced to prison or jail. So the great majority of people who are charged with murder are convicted. And when you look at the mean sentence for these defendants, the mean sentence for murder is approximately 20 years. The book says 244 months. 85% of those charged with robbery are sentenced to prison or jail. The mean sentence, about 7.5 years. 81% of those people charged with felony sexual assault are sentenced to prison or jail. The mean sentence, about 9 years. So you can see how some of these major types of felonies are dealt with. And when you talk about these kinds of cases, and we said that only really a small percentage of them are actually adjudicated by trial system, we find that Baum also tells us that in the largest 75 counties in the United States, the mean length of time it took to dispose of a felony charge was 92 days. And that 88% of all cases were completed within a year. And if they weren't completed in a year, most of the time the major reason why is the defense attorney was asking for an extension of the time. Why? Well, we know that one of the things we've said is that the United States Constitution says that in criminal cases you have a constitutional right to a speedy trial. And we can see that. Now, these trials obviously result in people being incarcerated in a large percentage of these types of crimes. And if you look at the United States jail population, now that's the United States jail population over time, we see that the numbers of people who are in jail have been going up dramatically. So, for example, in 1985, there were 200,000 people roughly in jail. By 1995, it doubled to 400,000. By 2006, 800,000. And currently it's over 1 million. So we incarcerate over 1 million people in the United States. And that is at a significant expense. So it's been estimated that it costs over $70,000 to build one single cell. And then it costs another $20,000 to $25,000 a year to house or take care of one prisoner. So you do the math. You take 1 million, you multiply that times the 20 to 25,000, and then have it for what it takes to do a single cell, because usually we have on average a little more than 2 prisoners per cell, and you're talking about billions of dollars being spent housing people in our jails. And it is a significant problem. So that's a little overview of crime in the United States. Now we want to talk about, how do you process a criminal case? How do you process it? Now, as we said, there are different types of crimes. And there are different severities of crimes. And we usually break that down into the idea of a felony versus a misdemeanor. A felony is any significant crime, generally of which the penalty is more than a year in prison. And a misdemeanor, therefore, is defined as whatever else is left, anything that's not as serious, for which the penalty is less than a year in prison. So the question becomes, how does a criminal case begin? How does a criminal case begin? That's the processing of a criminal case. How does it begin? That's the first question. And the way criminal cases begin are through a few different methods. First, someone can report a crime. I was victimized. Someone stole my property. So the victim can report the crime. Or an interested citizen can report a crime. Now remember, we said only 40% of victims report their crimes. So that's the first general approach you can have. The other way that a criminal case can begin is through police observation. Police observation. So the police are on patrols, they can observe a crime, they can observe people doing something criminal. They see someone in a store taking something, someone assaulting someone or battering someone, shooting at somebody. So those are the two major methods. So once a criminal case begins, the first part of the criminal process is what we refer to as the pre-arrest investigation. Pre-arrest investigation. So once the police become aware of a possible commission of a crime, they have to determine a number of things. First of all, whether the crime actually occurred. Was a crime actually committed? Because believe it or not, there's a lot of people who report crimes that never occurred. They report that something was stolen, but it wasn't. They report that they were abused, and they weren't. And probably one of the most famous cases of this happened in New York City, when Reverend Sharpton, Tawana Brawley, reported that she had been raped by a police officer. And Sharpton went on television, talked about how horrific this was. And at that point, Rudy Giuliani, when he was sane, was the mayor of New York City. And said that he had investigated the case and they found that this rape had never occurred. And sure enough, it had not occurred. So just because a crime is reported doesn't mean that the police take that as gospel. They have to investigate to make sure a crime actually did occur. So that's the first part. Then if there's sufficient information pointing to a crime, they have to determine who's involved and how did the crime occur, and whether or not there's sufficient evidence and information pointing to the guilt of a particular person. And if there is information, does it justify the arresting and the charging of that person? So what kind of things are we talking about? How do you determine someone's guilt? Well, there's lots of ways. We interview witnesses. So they go to the crime scene, they talk to neighbors, they talk to people who were around, they examine the scene of the crime. So if it's an attempted murder and someone was wounded, was there a weapon left behind? Is it a gun? Is it a knife? Whose gun or knife is it? Is it registered to somebody? Those kinds of things. They use informants. So sometimes what police will do, especially in cases of murder with gangs or that kind of thing, is they'll go to some of their informants and they'll say, what's the chatter on the street? What are you hearing? Who was involved? Who did this? Then if there's enough information, then and only then do you have an arrest. An arrest. So once an officer acquires sufficient information to justify arresting a suspect, they will take the suspect into custody. And now when you take a suspect into custody, that means you are transporting them to the police station and charging them with a crime. And this is where some procedural rights start coming into play. So this is where once you arrest someone, that's considered custody, and you get into this whole idea of in custodial interrogation. So one of the things that you have once you arrest someone is you have the person of interest in your physical possession. So you can do other things with these people. So as you book them after the arrest, you can search them. You can then ask for certain evidence that may be on them. You can photograph them. You can fingerprint them. Then you must inform them of their charges. You have to give them a right to a phone call. And you have to inform them of their Miranda rights and their rights to an attorney. After this is all done, the person will be held until they're presented before a magistrate. and the magistrate will inform them of their charges against them and their rights. And at that point, what we start to see is even a more thorough search. And the kinds of things that they will do is they might put them in a lineup. They might ask them for handwriting samples. Often it's not unusual for when they arrest someone that it's a very immediate arrest after a particular crime. So they might take their clothes. There might be blood spatter on their boots or their pants or their shirt. They can dust their hands to see if they fired a gun recently. So all of this kind of thing can be done. You can take hair samples. You can take DNA samples. Plus you get to question them. And again, what we said is they don't have to comply with it. But one of the things that we do tend to find is most people who are arrested and questioned waive their right to the Miranda rights. Now, I don't know why they would do that. That's not usually a good idea. If you're guilty, that's for sure. But most people do waive their rights, and therefore they usually give some kind of statement, and that statement can be used against them. So if they start to contradict themselves, oh yeah, I was at the restaurant with my friends, and then they interview the friends, and no, he wasn't with us at the restaurant. Oh, that's right, I remember, I was at the golf course. No, he wasn't at the golf course. Now at that point, you're making yourself look really bad. Then once you collect all of this evidence, you have to make a decision to charge or not. And this is where the prosecutors come into play. Now, many of our students who graduated from Mount have been prosecutors or district attorneys. So they're the people who sit down with the police to determine, do we have enough information to charge? And when we talk about this decision to charge, the kind of factors that prosecutors will look at are evidential criteria. What is the strength of the case? How much information do we have? Do we have witnesses? Do we have forensic evidence? Some pragmatic criteria, such as the severity of the crime. So if it's a murder, you're more likely to want to charge than if it's just a theft. And it's during this time of this decision to charge that the police and the prosecuting attorneys sit down and they go over the case together. And the prosecutors provide this higher review of all the information that's been collected by the police to determine the strength of the case. So they'll read the police report. They'll interview the officers. They'll talk to the victims of the crime. And these are very important parts of the case. And then the prosecutor must decide whether to charge a person with a crime or whether not to charge. And that can be a very complex decision. What we find is that prosecutors do screen out a significant percentage of cases that are brought to them. So again, if you remember back to when we talked about the 100 different felonies, what we showed was that out of those 100, 31% never went forward. So that generally means the prosecutor decided the case was too weak. But if they do go forward, then what happens is the next stage of the process, which is the actual filing of the complaint. The filing of the complaint. So this is the filing of the charges. And if they are misdemeanors, they can be tried before a magistrate court, municipal court. So for example, if it was a minor misdemeanor here in Alliance, something happened on campus, you would go to the Alliance Municipal Court. If it is a felony case, what happens is the complaint is set forth first in the local magistrate court, which then refers it, or we call binds it over, to the major trial courts of general jurisdiction, which, as we know in Ohio, are called the Common Pleas Court. So in other words, all felonies would be sent in this context of Stark County to Canton. And that's where the Common Pleas judges would deal with these cases. So if it's a felony, there's also an indictment stage, and the indictment will replace the complaint as the charging instrument. And that's just another stage where another group of people get to review the facts of the case as presented by the prosecutors and determine, was there enough evidence to bring this case forward? Now in Ohio, well over 90% of the cases that are brought by the prosecutor are agreed to by these grand juries. Once all of this is done, we have the first appearance. So the criminal defendant is presented before a magistrate, and in most instances, the person who's arrested for a felony is still in custody. But the law requires that they must be brought before the magistrate with unnecessarily delaying the case. So minimally several hours, at the most a few days. If you're arrested on a Friday, that's usually the worst day because you're not going to get a magistrate on a Saturday or a Sunday. At that point, the magistrate informs the defendant of the charges, notes their rights, and tells them again, like, they have a right to remain silent, they have a right to counsel if indigent, they have a right to a speedy trial, and they have a right to confront witnesses against them. If it is a felony, they will advise the defendant of the next steps in the process, and they will set a date for those. If it's a misdemeanor, you don't need this preliminary hearing. The charges are brought right to the magistrate themselves. Once that occurs, and if it's a felony, you have this filing of this information, this arraignment or indictment. And again, remember that if someone is indicted, that doesn't mean they've been found guilty. Okay, a lot of people get confused about this, but if you're indicted, all that means is a grand jury has agreed with the prosecutor that there is enough information to bring the case forward. So it is not a conviction. But once someone is indicted, it is brought before the trial court, and at that point the criminal defendant is asked to enter a plea. As we've already indicated, the vast majority of cases will not go to trial. Only a very small portion, about 4%, actually go to trial. And the reason for this is once these charges are brought, this is when the whole idea of plea bargaining becomes a major issue. Plea bargaining. So plea bargaining, which happens in about 95% of all the serious felonies, is when someone pleads guilty rather than going to trial. So the decision for a criminal defendant is whether to plead guilty or not. Now, as we said, most cases are adjudicated this way. Why would you plead guilty? Well, there's a lot of reasons, and one of the major reasons from the perspective of a criminal defendant is they expect a more favorable treatment if they plead guilty than if they go to a trial, deny the charges, and are convicted. So there's lots of different forms of plea bargaining. There's implicit plea bargaining, which simply would be, I'm a criminal defendant, I just plead guilty, I don't ask for any special consideration, but I expect that because I've been cooperative, the prosecutor will go easier on me. Then there is explicit plea bargaining, where a criminal defendant says to the prosecutor, look, I will plead guilty if you give me some form of reduced penalty. So one of the things you can do is what's called a charge bargain, which is when a prosecutor reduces the defendant's potential sentence or liability. And that can happen through horizontal charge bargains or vertical charge bargains. So horizontal is when there are multiple charges and the number of multiple charges are reduced. So let's say you're in a bar fight and you hit 4 or 5 people. Well, those are 5 cases of battery. So maybe what will happen is the prosecutor said, okay, look, we'll reduce it from 5 to 1, and therefore the amount of time you'd have to serve for that will be a lot less than if you convicted of all 5. That's a horizontal charge bargain. Then you have a vertical charge bargain. This is where higher charges are dropped for a guilty plea to what we refer to as a lesser included offense. So for example, shoplifting and assault can become disorderly conduct and harassment. Armed robbery can become just regular robbery. Murder can become manslaughter. Capital murder can become regular murder, all of which would mean less time in jail. The other thing that you can bargain for is what we refer to as a prosecutor's sentence bargain. So the understanding that the prosecutor will agree to recommend a sentence of a lesser amount with the expectation that the judge will follow that request. Now, what you have to understand is it's a little bit of a gamble because the judge doesn't have to abide by the request. So that's how plea bargaining works. Now, why plea bargain? Well, from the prosecutor's perspective, it saves a lot of time. It's shorter. You get a conviction, and you can go through more cases. And sometimes they don't have a lot of confidence in their case. So it achieves the desirable result, which is a guaranteed conviction. Now, a lot of people don't like plea bargaining. Why? Because they would argue that trials are the fairest way to determine guilt or innocence. And that to some extent it victimizes the defendant. So the defendant is under pressure to accept a bargain even if they didn't do it. Now the attack from the other perspective is that a plea bargain allows a criminal to escape the full punishment of the law.